The Agri Processor case provides a window into Kavanaugh's thinking when it comes to workers' rights. Like the conservative justices he would join at the Supreme Court, Kavanaugh has tended to side with employers in workplace disputes. If confirmed, he would almost certainly continue the Supreme Court's run of business-friendly rulings in contentious, precedent-setting cases that have weakened labor unions and class action lawsuits in recent years. Yet despite his conservative track record, it's unlikely that the seating of Kavanaugh would create a dramatic rightward shift in the court when it comes to labor law. That's because the justice he would be replacing was already a reliable vote for management in major decisions. Though often a swing vote on social issues, Kennedy tended to side with the conservative wing in blockbuster employment cases, including two from this term, Epic Systems Corp v. Lewis, which made it legal for employers to require workers to sign class action waivers, and Janus v. AFSCME, which will likely decrease union membership by making the entire public sector right to work. The bottom line, Kavanaugh will be a justice who will understand the employer's perspective, and I don't think it will be a significant change from Justice Kennedy in that regard, said Stephen Sufflas, a management-side attorney at Ballard Spahr law firm who argued a case before Kavanaugh. Kavanaugh has understood the employer's perspective in plenty of cases beyond Agri Processor. In 2014, he dissented in a 2-1 decision upholding the Occupational Safety and Health Administration's fines against SeaWorld in one of the most closely watched workplace safety cases in recent years. Kavanaugh disagreed. He compared working at SeaWorld to playing a sport like ice hockey that comes with inherent dangers, and, unlike his colleagues on the panel, argued that OSHA doesn't have the legal standing to regulate it. When should we as a society paternalistically decide that the participants in these sports and entertainment activities must be protected from themselves, that the risk of significant physical injury is simply too great even for eager and willing participants, he asked. Jordan Barab, a former OSHA official during the Obama years, wrote Tuesday on his blog Confined Space that the SeaWorld case shows Kavanaugh to be a threat to workers and to OSHA. The AFL-CIO Labor Federation and several unions came out strongly against Kavanaugh's nomination. The Communications Workers of America pointed to a handful of cases Kavanaugh decided that it considered anti-worker. Based on his record, we can expect that Judge Kavanaugh will continue to protect the interests of already powerful corporate CEOs instead of working families, the Communications Workers of America said in a statement. Sharon Block, a former member of the NLRB who is now a professor at Harvard Law School, said Kavanaugh's dissent in the Agri Processor case concerns her most. In that case, Agri Processor claimed that undocumented workers were not covered by the National Labor Relations Act of 1935 because a more recent law, the Immigration Reform and Control Act of 1986, said it was illegal to knowingly employ them. A detailed breakdown of the case can be read here. The majority of the D.C. Circuit panel disagreed with that reasoning, noting that the Supreme Court had ruled in a 1984 case that undocumented workers were indeed employees for the purposes of collective bargaining law. In his dissent, Kavanaugh argued that undocumented workers were no longer employees under the law due to the 1986 law passed by Congress. In Block's view, Kavanaugh's opinion sidestepped Supreme Court precedent and denied workers safeguards they deserved regardless of their legal status. It shows a willingness to go out of his way to write a whole group of people out of the protection of the law, said Block. And I find that to be troubling.